is Joseph McDaniel, and I'm an Arizona bankruptcy attorney. And after the 2005 amendments to the Bankruptcy Code, I also get to tell people that I'm a debt relief agency and that I help people and businesses file for bankruptcy. Some people who file a bankruptcy say, maybe I had to file a bankruptcy, but at least I'll get to keep some dough when my whiplash case pays off. Not. When people file their own Chapter 7 bankruptcy cases, the trustee has the obligation to track down any assets that may be valuable and non-exempt, and to liquidate those to obtain money to pay creditors in the estate, including the trustee. One of the most commonly misunderstood aspects of a Chapter 7 bankruptcy is that when a debtor files, the debtor no longer owns the assets in the estate. The assets, all of them, are now property of the bankruptcy estate. After the period of time to object to exemptions expires, the exempt property is deemed exempt by the operation of law and generally belongs to the debtor again. Note, in a market with rising real estate values, it may be a good idea to move to abandon a house if the house has a value close to the exemption value. That's because in Arizona, if a house increases in value, even after the period to object to exemptions has passed, the trustee can demand the sale of the house or the payment of an amount by which the house exceeds the exempt amount. It doesn't happen often, but it can be an interesting surprise to a debtor who wakes up and says, "What a great day this is. Nothing could go wrong on a day like today." Try to avoid saying that. Back to topic. A whiplash case or a medical malpractice case or a fraud case generally will not belong to a debtor after the filing of the bankruptcy. That's because the cause of action is not exempt under Arizona exemption laws, and therefore care, custody, and control and ownership of that case belong to the bankruptcy trustee the instant the bankruptcy filing occurs. The trustee has the option of hiring the attorney who was previously working for the debtor, or hiring a lawyer of the trustee's choice for the pursuit of the matter. The debtor, for his or her part, must cooperate with the trustee's lawyer to pursue the case if the trustee believes it has value for the estate. The trustee's lever to force the debtor to cooperate is simple. The debtor's discharge is at risk if a debtor refuses to assist the trustee in administering the estate. So a debtor may have a new part-time job after the bankruptcy filing, assisting the trustee in administering the case, which can include giving testimony in the whiplash case that the debtor no longer owns. As always, nothing here can be or should be used as legal advice. Get your own Arizona bankruptcy lawyer, because if you're going to file a bankruptcy in Arizona, you probably ought to know what's going to happen before it happens, because that lessens the owie factor. Thank you very much.